fans.
A partner in a law firm ignoring the partnership agreement which requiring all the expenses to be jointly approved and keeps on taking firm's money without the consent of the other party. Despite several warnings, he continues this conduct and causes mistrust and financial loss to the firm. The question is, what is the relevant principles of dissolution of the firm that can be applied in this situation? There are several ways on how a firm can be dissolved. One of them is dissolution by order of the court. Dissolution by order of the court can be done under few cases. One of them is willful and persistent breach of the partnership agreement. Section 37 closely provides that on application by a partner, the court may decree a dissolution of the partnership when a partner other than the partner suing willfully or persistently commits a breach of the partnership agreement or otherwise so conduct himself in matters relating to the partnership business that is not reasonably practicable for the other partners or partners to carry on the business in the partnership with him. For example, if a partner persistently refuses to keep a proper account, the other partner can use that as a good ground for dissolution since such conduct is not reasonably practicable for the other partner to carry on the business with him.
Hi everyone, my name is Faqihah Darwisyah, and today I would like to explain to you guys about the decided case based on Section 37 Clause D. So, the decided case was Smith against JS. Do you guys know what their court held? So, their court held was if one of the partners used the firm's money repeatedly was also ground for the dissolutions of their partnership agreement or contract. So, if you guys want to understand this decided case, let me give you an illustration. So, let us imagine that Ali and Abu was a partners in the business. So, in their partnership contract, they clearly stated that no one of the partners can use the firm's money just to buy or to pay personal expenses. So, but do you know that Abu has habit to take firm's money just to pay his personal and private debt? So actually, Abu did those actions repeatedly. So guys, basically, Abu was a breach the contract of their partnership. So hence, the other partners like Ali can use the notice of court to dissolve their partnership business because if they let Abu actions repeatedly happen, maybe their partnership business can be bankrupt or make more losses. Okay, let us go back to the question 2 earlier. So, does that question can be applied based on the Section 37 Clause D? So guys, the answer is yes. Right now, you might be wondering, right, why the answer is yes. So, let me give you several reasons for those applications. So, the first one is, in that question earlier, they stated that one of the partner had used the firm's money repeatedly for paying his personal debt. Second, in their partnership contract or agreement, they clearly stated that none of the partners can use the firm's money just to pay his personal debt or personal expenses. Number 3. So, if the one of the partners doing that action clearly they had breached the contract, right? So, if the other partners had give them several warnings and they still don't seem that they want to change themselves, so the other partner can use the notice of the court and dissolve their partnership if the members' actions can lead to the business loss and also bankrupts. So guys, in conclusion, the partnership contract can be dissolved if they have or they face the same situation based on the section 37 clause D. Okay, bye guys. So we go to the next question.
In question 2B, what basically happened is that there is a client who has personally appointed a partner of a consultancy firm as a trustee to hold 100,000 ringgit for the purpose of the client's children's education. However, without the knowledge of the another partners, the said partner misused the trust fund by depositing it to the firm's account, which later be used to pay for the expenditure of the firm. So, when this happened, what exactly is the liability that the firm had to bear?
Hi everyone, today I'm going to tell you about the law related to our situation just now. So according to Partnership Act 1961 Section 15, if a partner, being a trustee, improperly employ trust property in the business or on the account of the partnership, no other partner is liable for the trust property to the persons beneficially interested therein. A. That this action shall not affect any liability incurred by any partner by reasons of his having notice of breach of trust, and B. Nothing in this action shall prevent trust money from being followed and recovered from the firm if it's still in possession or under its control. So from this section, which is section 15, it's explained that if a partner is acting within his own capacity without the other partner's acknowledgement and improperly made use of a trust property in the business of the firm, which in this situation is referred to the act of the trustee partner to deposit the money, which is RM 100,000 ringgit into the firm's account and use it to pay for the partnership expenses, his other partners, who is totally unaware of the deed, are not liable to pay for the beneficiaries. And this would mean that the other partners cannot be sued by the client, and instead the responsibility fully falls into the trustee partner who did the act. And as for the case that is related to the situation, we could see from the case of ex parte Heaton, and this case actually provides a significant insight to this matter. So in this case, the partnership was formed by father and his sons, and the sons later on become a trustee of a will, but they misused the trust money for the partnership business. And later on, when the firm went into bankrupt, an issue was raised whether the firm was liable to recover the trust money or not. And the court actually held that the trust money couldn't be recovered by the partnership's property since the other had no knowledge about the breach of trust by his sons who were his partners. So, which meant that the trust money are fully liable towards the sons. And so, now that we already know about all of the cases and sections related to this situation, so let's go into applications. So taking consideration of all law related to the situation, section 15 can be applied because firstly, the trustee partner has deposited RM 100,000 ringgit to the partnership account, and this 100,000 ringgit was given to the trustee partner by the client as a trust fund for their children's education, which meant that the trustee partner is a trustee to safeguard the trust fund. But instead of taking care of the fund, the trustee partner instead went on and used the 100,000 ringgit to pay for the partnership expenses, and this action is actually done without the knowledge of other partners, which meant that only the trustee partner is liable to pay for the money. And since the 100,000 ringgit has been used to cover for the firm's expenses, the amount has to be fully covered by the trustee partner and not the other partners and not the partnership. So from all of this, we could say that the client can only sue the trustee partner and not the partnership as a whole and not the other partners. And that's all for me. So thank you. I will give this to my friend IMANINA to explain about the conclusion of the situation.
Overall, we can conclude that the consultancy firm has no liability to the client since the trustee partner misused the trust fund without the knowledge of another partners. This means that only the trustee partner can be sued by the client. But if the client intends to sue the partnership as a whole, he must prove that the rest of the partners are aware of the breach of trust by the trustee partner. In such cases, that the trust fund is still in the possession of the firm, the client may recover